Okay, we are now broadcasting to all attendees and the recording has started.
All right, thank you, Carrie, and welcome everyone. I call this monthly meeting of the Implementation Board to order. We will conduct this meeting via Zoom. All attendees will be muted until the public comment period. Please note that this meeting is being recorded. All visual, verbal, and written comments are public record. Board members, at various points in this meeting, we will engage in group discussion. To ask questions or share a comment, please raise your hand by clicking on the button to the right side of your screen, or you could just raise your hand and the camera will see you. Then you'll be entered into the queue. When the discussions formally begin, I will call on you in the order in which you raised your hand, or Harold will when he is chairing and facilitating the latter portion of today's meeting. After your turn, you can raise your hand again to be entered back into the queue. Let's do roll call. So I'll pass it over to Jeannie. Take roll.
We're going to switch it up on you today, and
Okay.
I am going to take roll.
All right, so sounds good.
I'll start. Nate Caminos.
Here.
Paula Carvalho.
Here.
John Chalmanek.
Here.
Harold Odom. Oh, I'm sorry, I skipped someone. I skipped Gordon McHenry.
I am present.
And then Harold Odom.
I'm here.
Damian Patanud.
Present.
Adrian Quinn. Michael Ramos.
Here.
Sarah Rankin.
Present.
Seema Reddy.
Present.
Juanita Spotted Elk.
Here.
Great. I know Pastor Anderson is not yet here with us, so we can continue.
Thank you. So yes,
Just a point. Adrian just said she had to call in. I'm going to go ahead and admit her and pull her over from the attendees list, if that's okay. Actually, because she's on her call, I can only allow her to speak. So Adrian is on the call, and Adrian, if you need to speak, go ahead and unmute yourself and do so.
All right, we'll move forward. Thank you, Carrie and Sola. Before we move on, we would like to acknowledge that all U.S. land is originally Native American land, and that we are gathered here today on the ancestral land of the Coastal Salish people. Here in the Pacific Northwest, they are the original residents and protectors of this land. Some of the Coastal Salish tribes are not currently recognized by the federal government, such as the Duwamish tribe, thus limiting their access to key privileges granted by federally recognized tribes. Native Americans have been present in our region for thousands of years and remain present to this day. So together, let us honor their elders past and present. We thank them for their stewardship of this land. In regards to public comment, we will have 10 minutes on today's agenda for public comment. If you would like to provide verbal comment, please type your name and the city from which you're calling into the chat function. Carrie will use this to build a queue for the public comment period of the agenda. In addition, you may use the chat function to provide written comments starting now until the public comment section of the agenda. Let's go ahead and move on to the next portion of our agenda, which is approving minutes from our January 13th meeting. I call for a motion to approve the January 13th meeting minutes.
So moved by Gordon.
Thank you, Gordon. Do I hear a second?
Second by Sarah Rankin.
Thank you, Sarah. All in favor to approve, please vote by saying aye, nay, or abstain.
Aye.
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 I heard all ayes, all good there. Okay, minutes are approved. All right, now let's go on to our training for the day. We have invited Mike Sinsky and Shelby McKithone to join us today to review the Washington State requirements related to our positions on a public board. It is a requirement of our board to complete OPMA and public records training. Mike and Shelby, welcome, and thank you for your time today, and I'll hand over the floor to you. You too.
Thank you so much. Again, my name is Shelby Michelton. I'm here from the King County Office of Risk Management Services. I'm going to chat with you a little bit today about both the Public Records Act and the OPMA, or the Open Public Meetings Act. I serve as the King County Executive Branch Public Records Officer. I've been in that position for about 9 years now, and I also assist DCHS in their public records responses. So we have today about 15 minutes on the Public Records Act and about 15 minutes on the OPMA. We also have about 15 minutes for questions, so we will have plenty of time to address any questions that folks may have. I will like to say I'm not an attorney, so I'm just going to be giving you some information today. And I hope that I can answer any questions that you may have, and that I hope that you find it helpful. I also want to say this is my very first time attempting to do a Zoom share screen and training and all that stuff at the same time. So I appreciate your grace in my first go around with this. And then Mike, do you want to introduce yourself?
Sure, I'm Mike Sinsky. I'm with the King County Prosecutor's Office. I've been with the office over 30 years. I had hair when I started in the office. I represent a number of boards and different departments in the county, and so I'm familiar with Public Records Act and Open Public Meetings Act issues. I'm going to assist Shelby, and I can assist with any questions that arise too. Just to be clear up front, I represent, the prosecutor's office represents county government, and your group is not, although it was created by county and city entities, it's an independent legal entity. So technically I'm not giving you legal advice as your attorney, but I'm just sort of providing background on Public Meetings Act and open public meetings issues. Shelby, I would say if this is your first Zoom meeting like this, I saw something on the internet yesterday of an attorney who was making an argument and his filter appeared as a cat. And he couldn't get it off, and so the argument goes forward with him with that image. And so you're a step beyond what many people are with your presentation. So anyway, glad to be here and look forward to this.
So unlike, just like the attorney said yesterday, I am not a cat, and I am here live. So I'm gonna share my screen and get us started. Okay, we are going to start today with the Public Records Act. And the Public Records Act, like the OPMA or the Open Public Meetings Act, are two of what the states call sunshine laws. And sunshine laws are our transparency laws. There are three main laws that are referred to as sunshine laws. Again, the PRA, the OPMA, and then our campaign finance laws, which are located in another statute. All three of these sunshine laws were started in the blowback after Watergate. They were passed by initiative by the people in 1972. And they are laws that have grown with us over the last 40 plus years. So we're going to start with the Public Records Act. The Public Records Act is Chapter 4256 of Washington State law. And we're going to start talking about what is a public record. So a public record is defined as any writing relating to the conduct or performance of any governmental or proprietary function that is either prepared, owned, used, or retained by any state and local agency. We call that prepared, owned, used, or retained portion as POR. And so when we're evaluating whether something is a public record or not, we're using that POR evaluation to say, did a government employee prepare, own, use, or retain this record for government work? The word used is very important in this analysis. We are responsible for records that we use for governmental purposes, regardless if we still have them. So If I am somebody who's going out and doing a site visit for a contractor that's doing county work, and they show me some data while I'm out at site, and I use that data to make a decision, the data is now a public record, whether or not I retained a copy of that. So that's one thing that we have to think about when we're talking about public records. So how is a writing defined? Because the statute uses the word writing. So writing means any handwriting, typewriting, printing, photostating, photographing, and any other means of recording any form or communication or representation, including but not limited to a whole lot of things, some of which we still use and some of which, like diskettes and magnetic and paper tapes and things like that, that we likely don't use very often anymore. We really want to think about what is a record that we might come across or use in our work. So it's a very long list, and again, any writing related to the conduct or performance of any governmental or proprietary function. So basically, anything that is prepared, owned, or used or retained by a public agency. So we think of things as public records as maybe the easier samples being a letter or a PDF copy of that letter, or maybe meeting minutes or an agenda. But we also need to think of things like databases, images, videos, things like that, instant messages, text messages, things that we use every day in order to do our work, or maybe things that we don't use very often. So one thing I really like to stress with folks is it's our duty to recognize public records requests. And public records requests are somewhat unique in that they do not have to be in writing. So any person or member of the public can make a public records request, even you and I can make a public records request, and we're not required to write the request down. We would highly prefer we get requests in writing, only so that we make sure that we understand completely what that person is seeking. But if folks want to give a verbal request to you, that is acceptable under the law. If we receive a verbal request for a public record, our best practice is to reiterate that request to them back in writing, saying, you know, this is what I understand your request to be for. Please let me know if I got it right, or please clarify if I didn't, just so that there is a record of what everybody agrees the requester is seeking. So we do ask that folks be cognizant of public records requests, and anytime you see or hear the following words or phrases, that should ping you that it might be a public records request. So something like a public records request, or PRR, a public disclosure request, or a PDR. That's a somewhat older term, although it still is in use by some agencies to refer to a public records request. Freedom of Information Act request, or a FOIA. The Freedom of Information Act is the federal equivalent of the Public Records Act. Sometimes if folks will say they're making a formal request for records, they're looking for copies of things, they're looking for all recordings, something like that. And then just to, when you're reviewing correspondence or having conversations with folks, be aware of hidden requests. And what I mean by hidden requests is somebody does not have to send in a specific form saying, I'd like to make a public records request. Often you will find public records requests in other types of communications. For example, if a member of the public is sending in an email to voice concerns or to write in support of something, they may have text expressing feelings, but at some point say, and I would also like a copy of X, Y, or Z. So we need to make sure that we're aware that we're looking for those things and that we alert public records staff as to the request. So the reason why we really want to be very prompt in recognizing public records requests is because we have, in addition to we always want to provide good customer service, we have legal requirements in responding to public records requests. So Agencies are required to promptly make available for inspection and copying all identifiable public records unless that record falls in with a specific exemption to the Act or another statute. Agencies have the legal duty to provide the fullest assistance to requesters. So the Public Records Act is one of the few statutes that says we have a legal duty to provide the fullest assistance to our public and our customers. We always have a duty to provide good customer service in general as public employees and folks that work for public good, but the statute actually says, you know, we are legally required to provide the fullest assistance. We also must perform an adequate search in all places that we reasonably records could be. So if I am reading a record and I think I've gathered all the records and I see a reference to another person I haven't contacted or another record that looks like it might exist, but I haven't looked into that yet, I need to keep searching because I need to search in all places that I reasonably believe that the record could be. We also have to respond in writing within 5 business days. And that the county in general is still doing that generally for all of our requests. We'll talk about the governor's proclamations regarding COVID a little bit more when we talk about OP&A, but there is right now a waiver for requests that come in via mail or physical ways via paper that we don't have to respond within 5 business days. That is not waived for requests that come in by electronic means. But I believe at least in the executive branch, we're meeting that 5 business days in general, regardless of the way that the request is coming in. So we have to do a few things in that 5-day response. So we could provide for inspection or copying the records that they ask for. So if I get asked for some sort of report that say a board or commission has provided, I can provide a copy of that report within 5 business days and say, thank you for your request. Here's the responsive records. I consider your request closed. Have a nice day. If say that record is already located on the agency's website, if that individual has internet access, and I'm going to assume they do unless they tell me they don't, I can provide a link to our website and say, thank you for your request. The record that you're seeking is located on our website. Here's the link. I now consider your request closed. Thank you. We also can acknowledge receipt of the request and provide a reasonable estimate of the time we need to respond. So say I get a large request that's asking for many different things and there's really no reasonable way that I'm going to be able to respond to that within 5 business days. I can respond to the requester and let them know, thank you for your request. We're currently searching for and reviewing responsive records, and we anticipate that we'll have a first installment available for you in 2 weeks. We could also seek clarification if the request is unclear. So if I just have read a request and I really am not sure at all what the requester is asking for, I can go back to the requester and let them know and say, I'm not clear what you're seeking. I can ask questions. I can say, can you provide me with more clarification? If there are portions of the request that are clear, I do need to move forward with those portions in addition to asking for clarification. So if I've got a request for 3 things and I know portion 1 and portion 2 are clear, I know what they want, but I'm just not sure about portion 3, I still need to move forward with portions 1 or 2 and ask for clarification on portion 3. So the last thing that we can do with public records requests is deny the request in accordance with the law. This is very, very rare that we are able to do this. And it's only for requests that there is you have to be a certain person to get the record. And so if I say received a request for somebody's medical records, I'm going to say, thank you for your request. I'll need you to submit a release of information form because you have to be a certain person in order to get those records. But again, that's very rare and it's more specific to specific departments and work groups. So the PRA requires agencies to do quite a few things, but there are some things that the PRA does not require us to do. So the PRA does not require us to create records, respond to requests for information, or explain records. But I will say I often do all three of these things. And the reason is I have a general customer service duty to the public and our customers. But the second is I also have a duty under the Public Records Act to provide fullest assistance. If there is a record that I can create for somebody that will meet their needs, fulfill their request, and give them what they needed, I'm generally happy to do that. The second is if I can answer questions for folks, or if I can find folks that can answer their questions, again, generally happy to do that. I'm here to provide excellent customer service. Explaining records, again, if records are confusing to folks and I'm able to find somebody to explain something for folks or do it myself, I'm happy to do that also. Before I did what I do now, I worked for DAJD and I produced a lot of jail records, and they were really hard to understand for myself who'd been trained in them and other people also, because they use lots of old mainframe codes and stuff like that. And so if I just gave folks records and said, nope, I'm not going to tell you what these mean, they really wouldn't have been as helpful to those customers as they could be if I had just taken a few minutes to explain them. So the PRA also doesn't require requesters to do certain things. So the requester isn't required to state the reason for why they're making the request. There is an exception. Again, there is a statute that says that lists of individuals cannot be used for a commercial purpose. So if I have a request for a list of individuals, I do have to go back to the requester and ask them to fill out a declaration telling me why they want the records. And it also doesn't require requesters to provide their names. So they don't have to say who they are, and they don't have to say why they want the records. They can be anonymous, and our systems support that. The exception for not identifying themselves is, again, if the request is for records that are only available to certain folks. So again, medical records, autopsy reports, things like that. So as I mentioned before, the Public Records Act requires that public agencies make records available to folks unless they fall under narrow exemptions. There are a variety of exemptions both in the Public Records Act and in other statutes or rules. When it comes to exemptions, agencies must identify each record that has been withheld or redacted and the legal justification for doing so. So I have to provide a redaction code key when I redact things that say each statute or rule that I'm citing as to why that information should be redacted and why that rule or exemption statute applies. And then a requester is able to sue us if we don't provide that adequate justification. Also, if only a portion of a document is exempt, only that portion of the document may be redacted. The remaining part of the document must be released. There is no exemption for non-responsiveness. So if only part of the record is responsive, the record is responsive. So if I send an email to somebody and the first portion of the email is about agency business, and then the second portion of the email is how great of a time I had, taking my new niece for a walk this weekend, that part about my niece is not going to be able to be redacted for non-responsiveness. So exemptions have to be narrowly applied, and case law historically has ruled in the favor of the requester because it's our duty as the agency to prove that the exemption both applies and is in good public policy. So I'm going to go through just a couple exemptions. There are over 400 in the Public Records Act itself, in addition to a variety of other statutes. There's some in the Public Records Act that are really specific, like the known location of ginseng plants in the forest is exempt from disclosure because those plants are valuable, I guess. So one exemption that's not actually in the Public Records Act that lies in another statute is attorney-client privilege. So that exempts a client's request for legal advice, the legal advice that the attorney provides, and the client's questions about that legal advice. The client must intend for the communication to be confidential. So I have to be wanting that legal advice to be confidential, and then my attorney responding back. It does not exempt client records just because the attorney is CC'd. So you actually have to engage the attorney asking for legal advice. So another exemption that is in the Public Records Act that we do use sometimes is called deliberative process. And this exemption is regarding our preliminary drafts or recommendations about policies, big level policy strategies, things like that, proposed collective bargaining agreements, proposed contracts. We may be able to exempt some of those things. However, once the policies or the recommendations are decided on or implemented, the exemption no longer applies and the records may be released. In order to use this deliberative process agreement, we have to meet all parts of a 4-point test. So the records must contain pre-decisional opinions or recommendations expressed as part of the deliberative process. Disclosure must be injurious to the deliberative or consultative function of the process. Disclosure would inhibit the flow of recommendations, observations, and opinions. And the materials covered by the exemption must reflect policy recommendations and opinions and not the raw factual data on which the decision is based. So if if folks are debating and drafting a new policy and have documents about that, but the policy hasn't been decided on yet, we might exempt some of those records from disclosure. However, if we just gathered some raw data, say census data or data about our clients, and we haven't put any assumptions on that data, that would not be part of the deliberative process. That would just be raw data and would need to be released. So there are some risks associated with failing to comply with the Public Records Act. And in general, the Public Records Act is a strict liability standard. So there's no exemptions for acting in good faith, which means we tried really hard is not a defense. It could be a mitigating factor if there were penalties, if we were found to have violated the Public Records Act, but it is a strict liability standard. So if a requester is not satisfied with our response, their recourse is to sue us in Superior Court. And if that requester prevails in the court case, they are entitled to penalties of up to $100 per day, per page, plus attorney's fees. That discretion as to how much of penalties to order is up to the trial court judge. The trial court judge has broad discretion in how they assess that penalty. So they could do per page, they could do per record, they could do per group of record. That is up to the court. And then again, if the plaintiff is entitled to attorney's fees and costs if they are to prevail. So those can get quite expensive on their own. So that is, in a nutshell, the Public Records Act. There are a variety of great resources online for more information. The chapter itself is 4256. The Washington State Attorney General's Office has a fabulous website that goes over both the OPMA and the Public Records Act. In addition, there is another nonprofit agency which governments fund called the Municipal Research and Services Center, also known as the MRSC. And they have a very large library also of information about the OPMA and the Public Records Act, is along with some really helpful templates that agencies are welcome to use to help them comply with the law. So that is the PRA.
Shelby, let me add a few things to what you talked about here. At the very beginning, you talked about 3 prongs of open government: the campaign-related laws, the Open Public Meetings Act, and Public Records Act. There's a 4th element that is that also bears on documents, and that's retention requirements. And so you probably want to talk with your legal counsel about what documents you have relating to your work would need to be kept. And typically it's things that have a substantive nature to them. Again, though, that's something you'd want to talk with your legal counsel about. Couple other points. Shelby, you mentioned the breadth of what constitutes a document. And I think it's important to keep that in mind for a couple of reasons. One, be mindful that even in contexts like a text that typically are sort of, they may be off the cuff, that those sorts of writings may well be things that are ultimately viewable by the public. And so it's just the notion that record is a broad concept sort of suggests that you need to be careful in what you're putting down in a written document. Another point regarding documents is, and also related to retention, there are issues that come up a handful of times every year where members of a board or public employees will do their public business on a private email or on private phones. And I would encourage you, and I'm sure your counsel will encourage you as well, to use as much as possible your public email. And the reason for that is if there are documents that relate to, that would constitute public records on your private email, there's an issue about whether that needs to be searched. And if all of your discussions, email discussions and whatnot are in the public realm on your public email, then that avoids that issue. So just an encouragement on that regard. Last point I would make with regards to the nature of requests. Really good points Shelby's making about the need for quick turnaround. And the only thing I would emphasize to you is because you have that 5-day turnaround, it's really important to get staff involved right away. If you get something that either in writing or a verbal request that sounds like a public records request, your staff is trained in how to deal with those and how to respond. And so just get them involved early so we don't accidentally miss one of the deadlines that could result in attorney fees or penalties.
Thanks, Mike. Those are all great points. And one thing that I also would like to mention that builds on Mike's point is that the court has ruled that something called metadata, which is defined as data about data, but is really all those sort of properties about records. So like if you went to a Word document and you looked at the about section, you see who created it, who modified it, when it was last saved, when it was last printed. For an email, it's kind of like the equivalent of the postage stamp and the canceling of the postage that goes over that when you send a letter. The public has a right to ask for all of that data. And so even if I, as the employee of the public agency, have a copy of an email, if I send an email to you, you have a slightly different copy because your metadata is different. And so if I were to get a request that was to ask for metadata, and about 5% currently of our requests do that, I'm going to have to come to you and say, I need each and every copy of this email. So if this email went out to 30 people, I'm going to have to collect all 30 copies back because of that metadata is slightly different or can be slightly different for each person. Say, you know, the email across different servers, that kind of stuff. So I completely agree with everything Mike just said, and I would plug that also. Okay, so I'm gonna go into the OPMA and then we'll have some time for questions. Okay, as I mentioned, and as Mike mentioned, the OPMA again is part of the Washington State Sunshine Laws. Again, blowback from Watergate, again, passed by initiative in 1972. And the OPMA applies to agencies and governing bodies. So it applies to all public agencies, and it defines governing bodies as the multi-member board, commission, committee, council, or other policy or rulemaking body of a public agency or any committee thereof when the committee acts on behalf of the governing body, conducts hearings, or takes testimony or public comment. So it's not always just the main decision-making body of an agency. At the county, we've got probably over 45 different boards and commissions that are covered by the OPMA, in addition to our main governing body, which is the county council. So we have to look at all the enabling legislation for all those boards and commissions to do an analysis as to whether the OPMA applies. There is a training requirement for the OPMA. So within 90 days of board members becoming members, and every 4 years, those members do need to be trained on the OPMA. So what we're doing here today, there is also online training available. So I mentioned that Washington State Attorney General's Office website. That website has 2 videos. There's an OPMA video as well as a PRA video. Doing those videos will satisfy the training requirements. And just like the PRA, the OPMA is a very strongly worded statute. It was, again, written by the people. There was a group called the Coalition for Open Government that wrote the statutes, and they're very strong in favoring the public as they should be, and as the public agency has a duty to be transparent. So the legislature finds that all public boards exist to aid in the conduct of people's business. It is the intent of this chapter that their actions be taken openly and that their deliberations be conducted openly. So the OPMA states that all meetings of the governing body of a public agency shall be open, and the public and all persons shall be permitted to attend any meeting of the governing body of a public agency, except as otherwise provided in the chapter, which we'll go over in the following slides. So basically, all of the meetings of an OPMA covered agency need to be open and accessible to the public. There's a few changes right now because of the COVID emergency, but we will go over those in the slides. So the OPMA has a variety of definitions. 3 important ones are meeting, action, and final action. So a meeting is a meeting when action is taken. And the court has added what I think is a helpful definition in Citizens Alliance for Property Rights Legal Fund v. San Juan County, which is a somewhat recent case that says a meeting of a governing body occurs when a majority of its members, or a quorum, gathers with the collective intent of transacting the governing body's business. So when there's a quorum of members and they're meeting with the collective intent to transact the governing body's business, the board is having a meeting, whether it really knows it's having a meeting or not. And we'll go into that in just a second. So 2 types of things happen at meetings. So an action, which is receipt of public testimony, deliberation, discussions, considerations, reviews, evaluations, and final actions. So if you have those things with a quorum, you are having a meeting. And a final action includes votes and final discussions, both positive and negative. So you could have a meeting and have actions, but not final actions. We cannot have a condition to attendance at meetings. So a member of the public shall not be required as condition of attendance at a meeting or of a governing body to register his name and other information, to complete a questionnaire, or other to fulfill any condition precedent to his attendance. So we can't require that folks sign in. We can't say, what is your name or contact information? We can't say you need to fill out this questionnaire before you're allowed to attend. The public has the right to attend the meeting. If at a meeting, a group causes interruptions or disruptions and the agency cannot restore order, an agency can clear the room and resume the meeting. However, the agency cannot exclude the press unless it was the press that was being disruptive, and agency can only take actions on matters on agenda. So if there was a disruption and the room had to be cleared, the agency, when the meeting is resumed, they can't take final action on anything that's not on the agenda. So no other business, things like that. As I mentioned, there have been some changes because of COVID and the emergency. So the governor has issued some proclamations. The proclamation states that all public meetings must be held remotely, except in-person meeting components may be available when it is consistent with the business meeting requirements contained in the miscellaneous venues guidance, which is incorporated to the proclamation. So this has been updated to reflect the current phase structure. In King County, I think it is possible to add a in-person component currently because we're in phase 2, although I don't believe that any of the boards or commissions are currently doing that because we're still in a very dangerous situation. So just like the PRA, the OPMA has penalties for violation, but the penalties are a little bit different. So the penalty for the board is that any action that is taken at a meeting that didn't comply with the OPMA can be found null and void. So again, like the PRA, the recourse for folks that aren't, feel like a violation has happened, if they want to, they can file a lawsuit in Superior Court, and the court can find, excuse me, that the action taken at the meeting is null and void because the OPMA requirements were not met. In addition, board members have personal liabilities to each member who knowingly attended a meeting in violation of the OPMA, and the court can order a $500 civil penalty for the first offense and a $1,000 penalty for each subsequent violation. And again, that plaintiff would receive can be awarded attorney's fees or costs if they are successful in their litigation. So back to meetings, there are 2 types of meetings. The first is a regular meeting, and agencies must identify the time and place they will hold their regular meetings. And then an addition, which is a somewhat new addition in the last few years, is that these regular meetings also have to have the agenda posted within 24 hours and then on the agency's website. And then the regular meetings will be a periodic schedule that are declared by the rules of your board or the statute or something like that. In addition to regular meetings, the presiding officer can call a special meeting. And a special meeting is whenever an agency has a meeting at a time other than their scheduled regular meeting, and that would be conducting a special meeting. So if you guys are having if you folks are having a meeting at a time that is not your regular meeting time, that would be the presiding officer would need to call a special meeting. A special meeting, there needs to be 24 hours notice to members of the media that have requested notification. The notice must be posted on the agency's website. And again, for a special meeting, action is only allowed on agenda items. So it must be an agenda item for action to happen, and there's no other business. So meetings have a specific structure. There's agendas. So those agendas need to be posted 24 hours in advance of the start time of the meeting on the website. Only for special meetings, it's only for agenda items. Minutes must be taken for all meetings and made available for public inspection. They should recite significant actions in the meeting. Many agencies choose to video or audio record the meetings. And there is an exception to that for executive session, which we'll talk about in a moment. And then the presiding officer can adjourn any meeting to a later date and time and location. Hold on just one second. And that includes regular, special, and executive sessions. But when a meeting isn't adjourned, so if you take, you're running out of time and saying, okay, we need to adjourn this meeting and we're going to adjourn till tomorrow at 9, you also must post that information on the door of the meeting. Agents and board members are not allowed to vote by secret ballot. So any vote taken in violation of this subsection shall be null and void and shall be considered an action under this chapter. So all votes must be on the record and not in secret. And then there is times where you can have what's called an executive session. So executive sessions are only allowed in specific situations that are defined in 4256.110. There's about 15 situations. And then before convening the executive session, the presiding officer has to state out loud on the record the purpose for the executive session, the specific reason for the executive session, which has to be one of these 15 reasons, and then when the executive session will conclude and the regular session will come back online. So the person would say, for the record, we're going to executive session, we will stop recording, the public is going to leave the room or be put into a break room, wherever how you do it on Zoom, and we will come back in approximately 20 minutes in order to resume the next portion of the meeting. The OPMA has a variety of resources, which were the same as the PRA, which is again the chapter, the AGO's website, and the MRSC. And that is the OPMA.
Shelby, I add a few things to your presentation there, just a couple. One with regards to the quorum. I don't know if the board has established bylaws where you've determined a quorum will be a certain number of members. But anyway, typically it's a majority of the total members. Your antenna should go up anytime you have a group that would constitute a quorum that are either meeting in person or electronically. And there's risk that when that group does gather that you could be conducting a meeting, whether it's something you're aware of or not. With regards to the electronic meeting, again, the Open Public Meetings Act requirements kick into gear when there is a quorum. When there's email exchanges or other communications among members, wouldn't necessarily immunize communications, the fact that the immediate emails are only between a few members. If those emails get passed along to others, it's a possibility that sort of, in the old days, we used to call it a telephone tree, where someone would call someone and that one person calls someone else, and before you know it, you have more than a majority of people who have effectively met. So just a caution to be careful of communications that are in an electronic format, even if it involves less than a quorum, because those can get passed along to other members and could create an electronic meeting inadvertently. And then the only other thing I would comment on is with regards to the difference between a special and a regular meeting. There are special meetings, because they're special, they have to be for a designated purpose, and you're not allowed to stray from that noticed purpose. Regular meetings, you have a little bit more flexibility in the statute. The statute specifically says that those original agenda items can be modified after the 24-hour in advance date. So again, just something to be aware of, and I'm sure staff would be working with you on those issues as well.
Thanks, Mike. Yes, you definitely don't want to have a meeting that you did not intend to have. So the statute says that members can travel together, can be in a room together, But anytime that you're discussing agency business, when you have that quorum, you're having a meeting whether you intend to or not. And Mike's comments about electronic means are really important, because you can be having a meeting via email, which would be expressly prohibited because meetings must be open when you didn't intend to be having a meeting. So that's, I would also stress that part. One thing that you might do on your regular meeting agendas, if you want some more flexibility, is to have a section for other business, because then it does give you flexibility to talk about other things that may not be specifically on the agenda. But again, you can't have something like that on a special meeting agenda. All right, so we have about 8 minutes for questions. So we'd be happy to take any questions that folks may have.
Thank you, Shelby and Mike. And yeah, we actually are a little bit ahead, so we got even 18 minutes if we really wanted to get into that. It was very informative and thorough, so thank you both for what you just walked us through. Board and governing committee members, any questions? I see Gordon and then Harold and Michael. So we'll go Gordon, then Harold and Michael.
Thank you, Shelby. Thank you, Mike. My name is Gordon McHenry. I had just a question of, I guess, context. In the training on the records, you talked, Shelby, about a verbal request can be interpreted as a request for public records. So I want a little context for us as I'm a volunteer. I'm not a municipal employee serving on this public board. Somebody says, hey, Gordon, I see that you're on the invitation board, and I really want to take a look at the documents pertaining to transitional housing that you guys were discussing. So the expectation is that I then convey that to the county?
So if it is something in writing, like they send you an email like that, I would say the best practice would be to respond back to that person, include the staff, and say, thanks so much. Really appreciate this. I'm including our staff so they can follow up with you on those items. If you receive it verbally, I would kind of take the same approach, which would be, thanking the person, because we always appreciate, that folks are interested in the work that we do. And then, sending a message to the staff, just want to let you know, I talked to this person, they asked me for this and that, can you please get back to them? We don't expect that board members are fulfilling public records requests, but that is something the staff is trained to handle. It's just getting that message to the staff in a timely manner.
Right. Thank you.
Another comment on that maybe would be to, if you have a request and not entirely clear whether they're making a formal public records request, it would be to ask them, is this something that you want to make a formal public records request for? Because we have someone who's designated to handle those if that's the case. And we like to have them in writing because it's clear to us what you're asking for then, and we can be more responsive. But I agree with what Shelby was saying. You don't always get that sort of clarity from people who are making the requests.
Appreciate both answers. Thank you.
Thanks. All right, let's go to Harold and Michael.
Well, this would be more towards the exception, and regarding phone calls, laptops, computers, our personal electronic devices. Even though I'm familiar with the Public Records Act, and I probably should have done this beforehand, where does that leave us now going forward, and when we have transmitted things on our personal laptop and we don't have a public device that we can use?
So the court has been clear that public records are public records regardless of where they are located. So whether they're located on your personal device or in a county email account. But the court has also, when it talks about employees, it says that there's a process that the employee does the searching for the records. So I, as the public records officer, don't say, come to the King Street Center on this day and hand me your phone and I'll get those records off of it. So the employee, and I would say the member, would have the responsibility for gathering those records and providing it to the public records officer for evaluation. The public records officer would be there to provide technical support, not give me your phone, but hey, here's some instructions as to how to do it. I'm happy to talk with you and answer questions you might have. But the best practice would be if the agency does provide an email account, to use that email account, because then you don't have those records on your device. I'm not sure if the agency would provide like a Microsoft OneDrive situation where you could keep records in a place that the agency can help you with that. But if you are going to keep records on a personal device, I would say to be very organized. So you only have one folder that everything goes into. So if you ever had to find it, you would be able to find it quickly and get it to the public records officer. So I wouldn't, I am given the tools to do my work without using my personal device. So I'm not in a situation where I have to do that. But if I wasn't, I would have one nice folder that said, agency work, and keep everything in there. And that way, if I had to sign a declaration later that said, yes, I did my searches, I would say I go to my folder that I keep all my stuff in, and I grabbed it and I emailed it back to the public records officer.
Thank you very much.
Mm-hmm.
All right, Michael.
So this is not so much a question to Shelby and Mike after your fine presentations, but a question to the whole group. We need someone who can give us legal advice. So in other words, we're getting informal guidance today, but we actually need an attorney who will give us formal legal advice, who's on our retainer, who will give, to questions we have, will give some official direction about how to proceed. And we also need a way of thinking through guidance. We need legal guidance about how to keep records and about meeting procedures. We're working backwards because we ran into there were a number of questions came up procedurally in the last week, and we were I think we did well, but we didn't have guidance telling us that this is how you're supposed to conduct your business. So I think we need a lawyer who will give us guidance. What we're getting today is informal guidance, and establish with the attorney what are the guidelines that we are to follow, because otherwise we're kind of left on our own. And that's not a good place. I don't really want to be in that place. And then there's a couple of set of relationships where this is going to play out. One is with the governing board. The governing board there's been some questions about procedures there. And so do we have to have our own counsel separate from the governing? And then what is our interrelationship and legal responsibility to that group? And then the second is to the new CEO. The CEO will have to work in synchronicity with us in terms of guidance and procedure, and what our role officially is vis-a-vis the CEO and public statements and disclosure. So I'm just saying that we need to follow up on this to formalize what is informally discussed today, and the guidance that we have today, certainly I would say we should follow, and then we should have the protections and guidance to be able to proceed.
Thanks, Michael. Just everything you just covered and then some too. I mean, just to note, this is not a one and done. We're good here, checking the box in today's meeting. And on that, it's a good point in talking to staff to agree with this as well. We recall even in the process of the CEO we had to work with Pacifica, Indiana, to your point in regards to what we had done. And so we're looking to continue in retaining their services. But we have this built out as we're building on this training and looking at next month's meeting as a discussion item to discuss this further, as well as additional items to what you just spoke to. But thanks for raising for everyone's awareness. Any other questions? Also, go ahead. I guess it sounds
Nate,
like...
hi, this is Adrian. Sorry, can you hear me?
Yeah, go ahead, Adrian. We hear you.
Oh, sorry, Nate. Sorry about that. Thank you, Michael, for raising those concerns, and Nate for indicating we can take it up next time. I think, as soon as, potentially we could still have Pacifica on retainer. And I think to answer your original question, Michael, the governing board, the implementation board, and, the staff entity should all be one thing. And so when we have a CEO on board, the CEO will have to figure out who's going to be the designated public records person, sort of similar to Shelby, and have that person handle all of our questions, or have somebody else on contract, I think.
Yes, great. Thank you, Adrian. And just also for the record, noting Pastor Anderson's attendance for today's meeting.
Yeah, I had another meeting. I had informed Carrie about
we noted. Yeah, we noted it. Thank you, Pastor Anderson, for joining us. Welcome. All right. Any other questions for Shelby or Mike? All right. Seeing none, thank you so much, Shelby and Mike, for your briefing with us today. Much appreciated. And thank you and good to see the governing committee members who also joined us for this training as well.
Thank you for your time.
Thank you so much.
Thank you. All right, let's move on to public comment. So now we'll take public comment. We've set aside 10 minutes to hear from members of the public. If you wish to comment and have not yet typed your name and city in the chat window to be called upon, please do so now. Each individual will be given 2 minutes to comment. Carrie will call on individuals in the order they have been provided in the chat window and unmute them. Carrie will announce when you've reached your 2 minutes, ask you to finish your comment, and call on the next speaker. Looking at the time, it's 3:03. I will close public comment at 3:13 p.m. Public comment is now open.
Hi, Nate. We do not have anyone signed up for public comment right now.
Okay, I will wait just a minute if anyone happens to be typing into the chat window now. Okay, seeing none. For those who had not had the opportunity to provide a comment, would still like to, we will leave the chat window open for the next 10 minutes. Let's move on to the next item on our agenda, which is confirming the one vacancy we still have on the advisory board. As we recall, this is the position we have voted to approve nearly all of the vacancy positions for the advisory board just a couple months ago. We are now going to be taking Dan Burton's nomination as in terms of the City of Seattle's for the nominee for as one of the two public funders for this. So I'll provide a brief bio on Dan and then look to entertain a motion for nomination and then discussion. So the bio I have for Dan is Dan has been nominated to fulfill the 19th and final seat of the King County Regional Homeless Authority Advisory Committee. The Continuum of Care Board has nominated Dan because of his expertise as a local funder. Dan is the federal grants manager for the City of Seattle, and in that role administers the Community Development Block Grant, CDBG, Emergency Solutions Grant, ESG, Housing Opportunities for Persons with AIDS, and Home Investment Partnership Grants, as well as providing some support to Continuum Care McKinney funding. He has worked for the City of Seattle for 2 years. For the 10 years prior, he worked for the Downtown Emergency Services Center, where he worked on homelessness and housing, behavioral health, and data analysis, all on the contracting, compliance, and reporting side. Do I have a motion for recommendation to approve Dan Burton to the King County Regional Homelessness Authority Advisory Board?
I move to approve the nomination. This is Adrian.
Thank you, Adrian. Do I have a second?
Second, Damien.
Thank you, Damien, for the second. Call for discussion on the recommendation of Dan Burton for the King County Regional Homelessness Authority Advisory Board. Any discussion? Okay, I will now I will call for a vote. Let's go ahead and go to vote. Sola.
Carrie Anderson,
Aye.
Nate Caminos,
Aye.
Paula Carballo,
Aye.
John Chelmanek,
Aye.
Gordon McHenry,
Aye.
Harold Odom,
Aye.
Damian Patnaud,
Aye.
Adrian Quinn,
Aye.
Michael Ramos,
Aye.
Sarah Rankin,
Yes.
Simha Reddy,
Aye.
and Juanita Spotted Elk.
Aye.
All right, the motion passes. Thank you, everyone. As I'll hand the floor, the gavel over, the virtual gavel over to Harold to take us through the remaining of the meeting. I'll also just call on Jeannie to pull up, to share her screen and pulling up a draft resolution as we get into the work of the business insurance ILA. Harold, you have the floor.
Thank you, Nate. So I'm basically turning it over to Jeannie. We have some talking points, and she'll go through the resolution. If you remember, I think 3 months ago, maybe Soli can refresh my memory.
I think it was September of 2020, Harold.
Yes. We voted on this in picking two agencies, and I guess these are the agencies that we've chosen.
Great. Harold, do you want me to jump in? I'm going to talk to you about an ILA between the Association of Washington Cities Risk Management Service Agency and the King County Regional Homelessness Authority. So as Harold mentioned, in September of last year, you voted and approved for staff to move forward with securing insurance for the Regional Homelessness Authority through an insurance risk pool. We have been working with the Risk Management Service Agency, also called RMSA, which is under the umbrella of the Association of Washington Cities. And last week, I'm losing track of what month is it? On February 1st, they voted to accept the Regional Homelessness Authority into their insurance risk pool. The risk pool allows for government entities to enter into joint self-insurance pool, which allows the more economical purchase of insurance coverage and risk management services. The ILA, we had a legal review of it, and they had no concerns. It's a standard ILA that RMSA uses with all of their member agencies. It lays out a range of definitions and recitals. It stipulates responsibilities of both parties and how to terminate the agreement. The coverage that RMSA provides is a standard package, and members can also opt into additional coverage. At this point, we're looking at the standard package. Authority staff will also have access to a range of consultation services and trainings that the RMSA provides to their members. And to move forward with the ILA process, you need to pass a resolution authorizing and approving the agreement. And that's what I have up on the screen here. And so this just notes what the resolution is agreeing to, and then authorizing the signing of the ILA, or the interlocal agreement. So the Association of Washington Cities Risk Management Service Agency is authorized and formed under RCW 48.62. It offers pooled self-insurance, providing cost stability and the potential for long-term savings. Whereas AWC RMSA is sponsored by the Association of Washington Cities as a service to Washington cities and towns, and I will just add my own and other government entities, of which the Regional Homelessness Authority is one. Whereas the King County Regional Homelessness Authority has reviewed and analyzed the AWC RMSA interlocal agreement, bylaws, and coverages with legal counsel for consistency with the city code charter of the King County Regional Homelessness Authority. And whereas the King County Regional Homelessness Authority acknowledges that after becoming a member of the AWC RMSA, the King County Regional Homelessness Authority shall be subject to assessments and any future reassessments as required by statute and the AWC RMSA. And whereas the King County Regional Homelessness Authority concludes that the interlocal agreement of the AWC RMSA would be beneficial in managing the municipal risks involved in providing services to our citizens. Now, therefore, the King County Regional Homelessness Authority does hereby agree to enter into and abide by the interlocal agreement, which, along with this resolution, constitutes a contract between the King County Regional Homelessness Authority and the AWC RMSA.
Any questions for Jeannie? Seeing none, let's go forward to talking about the health benefits pool of the ILA with SOLA there. The implementation board approved enrollment of the AWCDA, Association of Washington City's health benefits pool. We are recommending that the King County Regional Homelessness Authority enroll in the medical, dental, vision plans that are commensurate with the City of Seattle and King County standard benefits. We propose that the start of the benefits for all new employees begin on the first day of the month they start. We propose that the domestic partners are included in coverage, and that we propose that the basic life insurance is included. And if this board agrees, both Harold and I will provide signatures to this agreement. Sola, anything you wanted to add in addition to that, as well as?
There's not much more to add. Just wanted to provide you all the overview of the benefits that the individuals beginning work at the regional authority will have access to, and a clarification that at this time the ILA for the benefits is not actually required. I learned this late yesterday. What is required is just an authorization by the co-chairs of the board to approve the packages that have been identified by staff. And just want to verify for all your situational awareness that you're in agreement with the benefits that have been selected. We had talked to you all about this also back in September, and so if there are questions about what we're authorizing, let us know. And we are authorizing this on behalf of the regional authority. I should make sure that that's really clear.
Thank you, Sola. Any questions? Seeing none, do I have a motion for recommendation to approve the business insurance ILA and the health benefits ILA?
Kerry Anderson, so move.
Thank you, Pastor Anderson. And I see
Second.
Gordon for a second.
Yeah.
Thank you, Gordon. Call for discussion on a recommendation to approve the business insurance and health benefits pool ILAs.
Gordon here. I think it's self-evident, but I think it was Sola's point that we started this discussion back in September. Months have gone by. We're in a new calendar year. I just would like some affirmation that expected comparison, that whatever we approve would be comparable to the City of Seattle and King County benefit levels, is still, that assumption is still guiding this decision to move forward.
Yes, we are selecting the essentially the identical plans that City of Seattle and county staff are currently enrolled in.
Great. Thank you, Sola.
Yes.
Any other discussion? Okay, seeing none, let's go to a vote. I'll call for a vote. Let's go to Sola and calling a roll call.
Great. Kerry Anderson.
Aye.
Nate Caminos.
Aye.
Paula Carballo.
Aye.
John Chelmanak.
Aye.
Gordon McHenry.
Yes.
Harold Odom.
Yes.
Damian Patnud.
Aye.
Adrian Quinn.
Yes.
Michael Ramos.
Aye.
Sarah Rankin had to leave us, so we'll mark her as absent. And then Seem Reddy.
Aye.
Juanita Spotted Elk.
Aye.
So 11 ayes and 1 abstention.
Thank you, Sola. The motion passes. Thank you, everyone. And hey, we're ending our meeting quite early today. So I think this is the 5th meeting of the Implementation Board in 2021. It's only, 6 weeks into the start of the year, but we've got a lot done here to kick off 2021. And thank you so much for everyone's patience, engagement, consideration for all what we've done in the last 6 weeks. Much to be proud of. So Harold and I look forward to keeping you posted on what we have teed up for March. As we mentioned earlier, some discussion a little bit more on building off today's training that we just received this afternoon. But in addition to other items and talking about our board structure and how we're going to go about building committees and getting a little bit more into work on all that we have ahead of us. So thank you. With that, I'll entertain a motion to adjourn.
Motion to personal privilege.
Of course, yeah, go ahead, Gordon.
I just wanted to take a moment to publicly thank Nate and Harold for some really effective leadership of this still forming implementation board, successfully getting us to the point of hiring a CEO and running very inclusive but efficient meetings. And so I know I wasn't wanting or ready for that leadership responsibility, and I appreciate Nate, you and Harold doing so well. Thank you.
This is Harold. Just last month has been a little strange for me, running a little slow. So I like to thank the staff and Nate for helping me get back up to speed. I'm feeling a lot better, and I tell you, we all should just take care of ourselves. Watch out for that COVID thing that can knock you out. But staff and Nate, just thank you very much for all your help and keeping me up to speed. I'm back at work, and it just seems like one thing after another I have to catch up on. So Gordon, thank you. And everybody who's wishing me well. I'm sorry I haven't gotten back to everybody, but you know, it's a struggle sometimes. It's like that unmute button. I have to find it all the time. But I'd just like to thank everyone for your warm wishes and keeping my spirits up. So.
Thank you, Gordon, for your kind words, and for Harold, good to see you getting back so healthy and strong and sharp with all of us again. We're all very glad to see you getting healthier each passing day. And yes, that's like I mentioned, and Harold and I spoke to the governing committee last week. While it's been a lot of work, particularly these last 6-7 weeks or so, outside of these meetings to get us to this point, no, we wouldn't have been able to do it without staff. So really a special shout out to Sola, Jeannie, Carrie, and Gabriel behind the scenes here for supporting Harold and I and all of you and all the hard work that we've done the last 2 months in particular. But a lot more to go ahead in the head, and we'll have some obviously new members joining the authority team in that regard as well. So, all right, I'm going to re-entertain that motion now to adjourn.
Well, I second Gordon's initial motion, but I'll make an original motion for to adjourn. So again, thank you, Harold and Nate, and Sola and Gabriel and Carrie and Jeannie for so much incredible work.
You're here.
Thank you. All right, we have a motion by Adrian. Do we have a second?
Second, Damien.
Second by Damien. Thank you, Damien. All in favor say aye.
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 All opposed say nay. No nays. The yeas have it. We are adjourned. Thank you so much, everybody. Look forward to seeing you next month on our Wednesday, March 10th meeting from 2 to 4 p.m.
Have a blessed afternoon.
And stay safe out there this snowy weekend. Take care.
Oh,
Bye.
Bye.